You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. Hello, and welcome to Best Practices with Kenny Berger. My guest today is Tom Grillo. Tom is up there near Buffalo, New York. He and I had the chance to meet each other in Charleston at a brain injury conference about 5 months ago now, and then got to spend some more time out in Las Vegas at Steve Gersten, one of our past guests, seminars on 360 advocacy. And Tom is just a fantastic trial lawyer, great presenter, and a really good dad. For his daughter's birthday when we were out in Vegas, of course, he ditched the crew and made sure he and his wife and their beautiful young daughter had a wonderful time at a show. So, Tom, welcome to Best Practices.
Yeah, Kenny, this is great. Always great to see you. And, obviously we have become acquaintances here recently and obviously friends. So excited that we've had the opportunity to see each other here face to face more recently and multiple times. So thanks for having me on your show. I am a big fan. I'm a listener and I love it. So thank you.
Yeah, man. All right. So you're up in New York. You're doing a great job as a trial lawyer. You didn't start out professionally as a trial lawyer. Before you were doing trial work, you were actually in law enforcement.
I was, Kenny. Yeah, I'm up here in Buffalo, New York. And, you guys may have heard of a little football team called the Buffalo Bills. So that's right here in our backyard. And, but yeah, born and raised in Buffalo. My folks are from Buffalo. I was born here. My wife is from Buffalo, and this is just a great town. This is where we are. But you're right, Kenny. I did not start out my career as a lawyer. In fact, I think as I was, growing up, like most kids, you have a dream and you follow your dreams and what you're going to do for work. My passion always was to work in law enforcement. So my pursuits were to always follow that and to go through the process, the education, the training, and do what I could to try and get hired in that realm. As I was getting close to finishing my undergrad degree, I had not yet been hired by a police agency, so I had wanted to continue my education efforts, and so I applied to law school. And right around the same time that I had gotten my acceptance to law school, I'd gotten hired by a local police agency, and I was so excited about the opportunity to start in that I took the job with the police agency. And I deferred my entrance to law school for 1 year. But then the following year, I got hired by another police agency, and that was a police agency that in the town that I grew up in, and was really really a dream of mine to do that. So I started working there. And in my third year of law enforcement, I went to law school, and that was just exciting. But again, as I flash back to my career in both law enforcement, where I spent a little over 21 years doing it, and then obviously moving on to practicing law, I tell people whenever I get the chance to, many people in life don't get the opportunity to find a job or a career or a calling, I guess, if you will, that they're passionate about and they love. And I've been blessed to find two jobs, careers or callings, I guess, as I like to say, that I've been able to do. But I really think that the background in law enforcement and the opportunities that I had and the training and experiences really has provided, if you will, the framework that allows me to help our clients in the personal injury world and how we represent them in our firm. And it's given me a pretty good background.
How so?
One other thing I'll say, I guess, is just structure. And Kenny, I know that you and I've shared this conversation before, and I like to say it whenever I give a presentation or whenever I'm talking to the lawyers. I think a big part of what we do is certainly being able to prepare for our cases and making sure that we are doing everything we can to help our clients and get them the full and fair compensation that they deserve. And I always say, and I know you've heard me say this, but we oftentimes think that we're going to rise to the occasion, and we're going to be able to just overcome whatever occurs. And I would say that law enforcement has taught me that we don't necessarily rise to the occasion. What we're usually doing is we're falling to our level of training. But as trial lawyers, what I like to say, we're falling to our level of preparation. And I think that's something that is important. And whether we realize that or not, but that's in the heat of the moment, whether we're in trial or we're in a deposition or we're arguing a motion, at the end of the day, you can know your facts cold, but at the end of the, you're standing on your feet and you have to react.
Yeah, and something you and I've talked about is like if I've never done it before, I can't realistically expect myself to do it for the first time with an audience. Maybe, but my goodness, I mean, it seems like it's a lot easier if I've done it over and over and over and figured out ways to make it better along that path. I mean, anytime I prepare, I'll give you an example, running through a presentation, an opening, a direct, a cross, and close, whatever. Like the more that I've practiced and honed in, the more I thought, oh, you know what, this is a way to improve on it. Not, all right, let's just get up there and see how it goes. Because chances are, um, it will take a turn. Chances are there will be the unexpected, right? Like my plan, like we were talking about right before we hit record on here, my plan is not the only plan. Every other human being on the entire earth has a different plan going into that day, typically than I do. So understanding different contingencies, different directions that things can go, and like you said, falling back to that level of preparation typically is how I've seen things go, and just in my own life, that's proven true over and over again. We're here to talk mainly about jury selection, and you've done a tremendous job in various trials and two recent cases in particular where there were some observations that you made, some patterns that were really becoming more apparent to you, I believe, in part because of work you've done with consultants when it comes to jury selection. So that's the table's set, Tom. Kind of run with us when it comes to best practices on jury selection.
Yeah, well, I think it's first of all, I think it's interesting and humbling at the same time to ask me the question of what are best practices in jury selection, because geez, I certainly don't know that. But I can tell you what I've found maybe some success in, and what the folks that I've surrounded myself with, and my partners in my office, and what we've done. But I guess what I would start out with this is that grab the materials, right? We all know the authors, but grab the books. I guess for our show, I grabbed a couple of books that are just kind of sitting next to me here, but one of which is this Hostage to Heroes book. And I know you're shaking your head because you've seen it, but I've got a stack next to me, whether it be, 12 Heroes, One Voice, or Rowley has done some, David Ball and Artemis Muckapoor, Mitnick. I mean, the names go on and on of these folks that have spent considerable more time in a courtroom than I have trying cases. And what I get from all of them, and the Hostage of Heroes book is really interesting because that's from a consultant standpoint, right? And if we've kind of learned a little bit about Sari in that regard, her background is not as a trial lawyer, right? But it's a person with keen observation, knowing what works. And I think that's what I think all of the great authors that are writing about in this situation is really is that they have taken their experiences, and they've kind of modified that and given back to us, and because it works, right? And because at the end of the day, jury selection is just like you and I going off, whether we're at our favorite restaurant or we're playing golf or we're at the supermarket, and you're just having a conversation with somebody. And that's really I think what it boils down to. Joe Freed talks kind of a little bit about the idea of vulnerability. I shouldn't say a little bit. He talks a lot about this position of vulnerability, and just getting it out there. So, I think there's a couple of things that I hate to keep going back to conferences and things that work, but I attended a AAJ does a voir dire workshop, and it's like a 2 or 3 day session. You've got incredible speakers that come, but you also have the opportunity to test your skills live to mock panels. And again, Kenny, I know that you and I, you talked about, preparing and doing what you can. Again, it goes back to that level of preparation and trial. And I know when you haven't done something in the past, you don't know how to do it. Well, that's just it. Remove yourself from the not knowing how to do it part. And I'm not suggesting that you don't know what to do because of the intellect, because I think we're always going to struggle with knowing everything. But we certainly can run those scenarios, right? Those mock trials, those pre-scenarios, kind of like a professional athlete, or even somebody in Little League. I mean, I think about how many times I drop our son off at hockey practice, or our daughters ride horses, and how often they practice, right, before their big game or before their big event. And as trial lawyers, why as adults do we have to stop kind of acting like kids in that regard and lose sight of our practice? And that's really what it is. If you're going to play in a golf tournament, right, probably the one thing that many people do, if you're like me, is not I enjoy golf, but you're never going to see me doing it as a career. We go get a lesson, right, because we want to try and get better. But for some reason we lose sight of that in our profession as trial lawyers. So I would say to you, and how do we achieve that quote unquote best practices? Well, it starts with learning from the best, learning from the folks that have done it before us, that are doing a great job. But find that case that you have that you can bring a consultant in on. And again, I know that this is an expense and they're costly, and sometimes it doesn't make sense. Maybe you don't have the right case, but maybe you have an attorney in town. And Kenny, you and I had this conversation just not too long ago, and you mentioned the fact that you like to reach out to lawyers and say, hey, can I get on a case? I want to try a case with you, or how can we work together? And I think that's a huge thing, right? Co-counseling with other attorneys to try and get involved. The bottom line is just practicing your craft, right? And we certainly don't want to practice it for the first time we get in the courtroom. So if you can't afford a consultant, and we'll talk more about that in a little while about working with them, but how can you do it on a inexpensive route? Well, I don't know, maybe you grab 10 folks from the community that or that you just put the feelers out on Facebook, buy everybody a pizza, and give them a couple bucks and ask them to sit there and listen to you, and don't be afraid for the criticism that are about to come, because that's what you want, right? You want to be able to have that mock scenario to present your facts, and that truly, because I don't think, in my opinion, I don't think jury selection is like riding a bike. I don't think it's like, the golfer that plays golf once a year and expects to do really well. I think you have to practice, or at least I do. I have to practice. I mean, maybe one day I won't have to practice. So I think it all goes back to preparation, and trying to prepare yourself for the game. So I think if you have that opportunity to do that and do those mock trials, I think that's going to start your success, I believe.
And Tom, in these two cases, and the two cases in particular that you and I have discussed are very, very different cases. Very different. I'll let you speak to that as much as you'd like. But in striking juries in both of those cases, what were some of the commonalities in terms of your approach, or commonalities in the way that the defense approached it?
Yeah. So I think that what we see anyways, and I think what's kind of happening nationally is this, we all heard, I think, as lawyers starting out doing this kind of trial work, is the idea that we want to close off the jury to anything bad, right? We don't want the jury to know some of these bad facts, or we don't want juror number one to say something bad, because then all the rest of the jurors are going to hear that, and you're afraid you're going to lose folks. And I would say just absolutely just the opposite, right? As we think back about what we need to do, and in jury selection, and that is really starting out with trust and honesty. And I know when we listened to Nick Raleigh or him present or read his stuff, he uses the word brutal honesty. And I don't think there can be anything more far, or closer to the truth than having brutal honesty when you're there in jury selection. If you lose credibility, or you don't come across as authentic in your message or what your facts are about, I think you might as well go home, because I think, these folks, these jurors that you're talking to, forget for a moment that they're jurors, but they're human beings. And you have to pass the sniff test. It's not that they have to pass the sniff test to you. You have to be accepted by them. And I think that's a big part of it, right? Getting their permission for you to be there with them. And it's not that they're not the right juror for your case, but is your case the right case for them? And I think that's kind of the transition. We think about so much exclusion, and I've got to get this type of person off. And I think we're losing sight of that in some ways. And, some of the experiences that I had in some recent cases, and having the ability to work with trial consultants, what was really, I think, apparent to me is we know that we prepare for our cases, and we go to sit and do a deposition, and we have these tremendous outlines, and we have these discovery materials, and we have great written thought. But I think what the trial consultants really helped me hone in on is my outline and my questions that are specific. And I think in many ways, a lot of the same questions we have to get to, right? Such as the money question, right? The non-starter questions, these beliefs, these value systems that everybody has. Listen, you and I have them. And there's nothing wrong with certain belief systems that you have, or backgrounds, or things that you were brought up with. But what we need to get to is, how do those values, those belief systems, these quote unquote things that Keith Mitnick will talk about in this bias, right? I can't say the word bias as nice as he does, but how do we get past some of those things with our cases? But I think sometimes we are our own worst enemy, I think, as the trial lawyer, because we come in with so much fear and anxiety, and making sure that we get it so perfect, that I think that we're not ourselves. And I think if you can be yourself in that moment, and just be the same guy that I was when I met you for the first time, Kenny, and vice versa. It wasn't a show, right? It's just, that's how it is.
And you were talking about credibility and authenticity. It's things we've talked about a lot, and you hear discussed all the time. One of the things that stands out to me right now when it comes to authenticity is, am I exhibiting what's like really going on with me? Or am I bullshitting you? And what I mean by that is am I in alignment, like in terms of how I feel, how I'm acting, how I'm speaking? Is this real, or is this kind of what I think that Tom Grillo might want from me in this moment, such that like I elicit the response I'm hoping to gain because we're on a podcast, blah, 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 blah? Or is it like, hey man, yeah, dude, I always enjoy when we talk, and we're just having a conversation. And so if I'm coming into it, and I know that I'm scared to death, and I already don't like this person, I'm already looking for all the reasons that I want to tell them why they're wrong and I'm right, yet I'm trying to do it in this like very gentle, very, very open, very vulnerable. It's gonna be like, who is this? This guy, I know he's up to something. He is scheming on me. And all the other jurors are watching, being like, no, this is fake. Like, they clearly, I can tell by, the subtle intonations, the body language, whatever it is, they clearly, have a problem with this juror, yet they're acting like they want to have this juror over for dinner. Nope. Can't trust them. And so, when I think about authenticity and I think about credibility, it's like, am I being real? Am I really in alignment? Or am I just kind of trying to put on for purposes of persuasion and the illusion of control?
Yeah, that I'm going to hone on that last word that you said, and that was persuasion and control, right? And listen, again, this is something that Joe Free talks about. I just had this conversation with him about, like, sometimes you just can't control things, right? And I think if we understand we can't control the moment, and we might not be able to control the outcome. And the second I think that we put our control and power over something, that we're going to change it, that means we're trying to persuade. And yeah, so trial lawyers, obviously it's our job to persuade, right? There's so many books and articles and presentations and everything on the art of persuasion and how do we get somebody to buy our stuff, right? We're not salespeople. And I think when you try to persuade, I think people know that, right? And it's okay to deliver your message and tell your story. And if you tell the story from the heart, listen, at the end of the day, sometimes you just have bad facts, right? And clearly when you have good facts and you have this really nasty corporation and they've done really bad things, and those are just incredible facts that everybody can get behind, sure. But you might have other issues you got to deal with. Maybe the money issue is a problem, and you got to get over that. But sometimes you just have bad facts. But I think if we are willing to be vulnerable and put ourselves out there, and you know what, if I'll give you an example. I had, in a recent case, I had a juror that just lit up on me, and I'm sure you've experienced it, where they called me out and called me out on being a greedy trial lawyer and a plaintiff, and in fact got right down to the brass tacks of, aren't you gonna get paid X? And you know what? Like, that made me nervous. Was that part of my preparation? It wasn't. But you know what, Kenny, what you said and what I fell back into of working with our consultants, that's okay. Just be honest with your answer. And you know what? You just let that person talk. And you can say, sir, I understand that you and I are maybe not going to see eye to eye on everything here, but I do appreciate your honesty. And I want you to tell me about that. And you're right. Our firm, we're going to get paid if we're successful for our client. Just like perhaps somebody else here is going to earn a wage if they're doing something. And in this particular situation, this person was a contractor, and like them, they're going to get paid if they go out and decide to do a job for somebody. Now, we may have a philosophical difference about how much the lawyer should get paid versus in relation to the recovery for the client, and I understand that. But isn't that a beautiful opportunity for that, when you've given that person a chance to talk? Isn't that a beautiful opportunity then just to look around the room and say, who else feels the same way about Mrs. Smith? And I think that's the part of it. Whereas everyone used to, I don't say everyone, but there was a thought process that we should shut that off. We don't want to hear from that we should automatically exclude that person right then and there because they can't do anything any good. Well, guess what? I believe that you are given a blessing in that moment, and show this man some grace and let him or her talk, and then allow everyone else to talk, because sure enough, you might hear the exact same thing, maybe from the entire panel, and that's okay. Just go on to the next.
One of the things I've said a ton for the last couple of years is I'd much rather know before a jury is impaneled than after a verdict is rendered. Because I came up, and especially in South Carolina, where we have significant limitations by practice on voir dire. It's not by law. It's really by custom, because ultimately it's at the judges, and we have wonderful judges. It's at their discretion. But by practice and custom over a lot of years, there just hasn't been attorney involvement to any meaningful degree in voir dire. And where there has been, it's the notion of, well, you can submit questions to the judge, and perhaps the judge will ask those questions, but without any follow-up. And I got taught the exact same way you did. I remember this is early in my career. We were getting ready to try a criminal case, and it was a DUI case. I very quickly learned I did not want to do criminal defense. I didn't like criminal defense. I was like the criminal defense lawyer who'd watch the video and be like, "Oh, you did it. Yeah, you're guilty." The problem was a lot of times they were getting overcharged, but that aside, I remember asking like, "Hey, do we want to know about anybody, who might have been hit by a drunk driver, family members, and other people who've ever been charged with DUI?" And I got told like, no, like absolutely not, because we will poison the well. Now, fast forward 15 years, and what I know now is, hey, the well is already poisoned. We just need to figure out who drank a bunch of it, and who, on the other hand, can give us a fair shot and give the other side a fair shot as well. Because it's no more fair here to the defense bar not to know who the jurors are, their life experiences, their biases, than it is to our clients typically. But I love that you brought up the point of, no, let's get all of this stuff out. And the beautiful thing is, once you gave that juror who lit you up the opportunity to speak and to say more about it, and who else, who else feels the same way? Back to Nick's point on brutal honesty, you're giving everyone permission in a completely open environment to say whatever the heck they want to say, which is fair to both sides.
Yeah. Yeah, I agree with you. And I'll tell you a funny story about kind of the open and honest and letting everybody talk. In one of the recent cases, the defense attorney actually, went to the judge and said, "Hey, Mr. Grillo, he's got everybody raising their hand and they're talking, and judge, this feels like we're sitting around a bonfire at a fraternity party. I mean, this nonsense is to stop." And I thought about that for a minute, and I look back at our two consultants, who, again, I was fortunate. Again, my partner, John Froman, put us in absolutely the best position in our case, because we had these consultants, not only the opportunity to work with them and prepare for the case, but have them with me during jury selection, and it just live and real-time feedback and pivoting when needed. And I just remember looking back at both of our consultants when that moment happened, and they just I think their smiles touched their ears. It was just so big, because that was what we wanted, right? We wanted that group was forming, hands are raising, people, they couldn't wait to talk. And people were agreeing with each other. And you said something about who else. It's amazing, isn't it? I think one of our presenters in Vegas talked about words that matter, I think that's the book that was talked about. But it's so true, right? When the studies will show, if you ask those questions, anyone else agree, anyone else, it kind of starts to close people off and shuts them down. But who else keeps people going? So it's just interesting little style. Go ahead.
And same with, if you're talking to somebody and you get to a point in the conversation, you say, "Is there anything else?" You're signaling to them, shut up. Like, they know in their mind, be quiet, because this person is having a conversation. Instead of, what else would you like to discuss? Which is, hey, I'm here, I'm open, whatever you want to talk about, we can. So whenever it was I first learned that, I was like, oh yeah. Because I mean, for years I've been like, anything else? Which was, again, my way of being like, this conversation's over, I'm ready to move on. But what else would you like to talk about? Is, hey, it's an open invitation. If there is nothing else, it's like, no, I'm good. I'm like, all right, good. One of the things that I struggle with, and again, where we get to do more of voir dire than anywhere else, honestly, is, at different workshops. We built a 6-person jury box and witness stand at the back of our office, because square footage is less expensive in Columbia, South Carolina than some parts of the country. But in practicing voir dire, I realized, again, one of the things I struggled with was I'd be in a rush, right? Like I'm talking to Tom, and I'm like, kind of this self-imposed clock on myself where I'm like, wait, I need to I need to talk to Chelsea, or God, if I'm not talking to Chelsea or to Brad or Jason, whoever, they're going to get frustrated. So I really need to cut it short with Tom. And what I realized is it was exactly the opposite. Like, the more Chelsea could see that I was genuinely interested in what Tom had to say, the more I was signaling and telling her, honestly, that when I got to her, I was going to be genuinely interested in what she had to say versus the show of subtle or obvious flagrant disrespect to another member of the panel.
Yeah, that's a really good point. And it is uncomfortable, isn't it? I know exactly what you mean by that when you're standing there and you don't know, am I spending too much time? Does this person just want me to move on? But I think it goes back to, getting that permission and making sure that you have that juror's permission to engage in a certain line of questions even. Don't just assume that it's okay to talk about things, and don't think it's okay that for you to call on them. And I think getting permission first, because remember, at the end of the day, these folks are there for you, not by choice, right? No, nobody was driving on the road that day and said, "Hey, you know what? I think I'm going to call in today from work. I'm going to see if they need me on that jury." So they weren't there by choice. They were mandated to be there. So let's not forget about some of those issues that maybe they've come to. It's interesting, again, going back to recent experiences. I had a person on my jury that was not yet seated, and we're still going through the process. And there was a lot of concern and frustration about outside sources, like whether it be or conflict with the family, for example, right? Having children and the time of being away from your family. And at the end of one of the days, that I could tell this person was really frustrated, and it was making me nervous that how would this person do in a trial that could last 2 weeks? Were they going to be there for us in the end? And again, this particular case, we had some absolutely horrific catastrophic injuries. And were they going to be there for that amount of time? And I went home that night and talked with my wife about it. And she gave me the perspective, obviously, of being a mom and having 3 young children and having gone through those difficulties. And she really talked me through that process. And the very next day, when I went in there, I started with this particular person, and I simply asked permission to talk about it. And I said, I've had really a lot of time to think about some of the discussions we had yesterday, and I now understand your fears and your concerns. Is it okay if you and I talk about this a little bit? And it was an absolute evolution in that moment with this person. And the person that I thought that absolutely could never be on this jury came around. Because why? Because I genuinely cared about what she was thinking about, right? And what her feelings were. And I think that's just it, where, your jurors are going to do the right thing for you. But they need, I think, number one, they need the honesty, they need the authenticity, as you said. And sometimes you just need to work through some of their fears.
And something that stood out to me recently, it wasn't in the context of jurors, it was actually in the context of taking depositions. You may be giving that person, be it a defense witness, expert, a defendant, the ultimate company man, company woman, 30B6 party witness, a juror, the judge, whoever. You may be giving them the first truly focused, caring, empathetic audience that they've had in a long time, if ever. I mean, think about times, and you and we've talked about it and seen it, and sometimes people will be like, well, God, that witness just rolled over for you. And it's like, no, they didn't. They made a decision, like,
Yeah,
ultimately for themselves to come clean, to share what was really going on, because someone gave them the avenue to do so. Someone actually cared about what they had to say and who they were, and kind of give them the opportunity for almost absolution in whatever form. a real audience. And these may be, I mean, for jurors, I mean, these folks get home, if they live with somebody, a significant other may say, how was it? And they think they kind of have to fall into character, like, oh, jury duty, it's ugh, ugh, ugh. And then they move on to something else, right? And they haven't been heard, they haven't been seen, none of that. And then all of a sudden, Tom Grillo says, hey, tell me more about that. I want to understand. They're like, well, Tom, in that case, and all of a sudden it's like,
right.
It's not a counseling deal, but it is therapeutic to be heard, especially in a world where no one's really listening.
Yeah. Yeah, I think that's huge. And you said something a moment ago, maybe you've heard this or read it, but Satch Oliver talks about that whole idea of maybe your first question in your deposition is not the general background or how this crash happened, but how about how are you doing today? Especially think about that in a catastrophic situation where the person you're about to depose is the one, forget about the legality of it. So when I use responsible or the cause of, they were the one that was directly involved in the happening of the changing of your client's life. And how powerful is that this person was probably prepared by their attorney, by their company, by whatever, to come in there and just like be strong, be hard, don't give away any of the company secrets. And then here you are, you come in and you ask, how are you doing? This has got to be really tough. Like, how powerful is that?
Yeah, one of the things I've said to witnesses before is we're going to do this together. This is going to be hard, but we're going to get through this together. And I remember the first time I said it, I couldn't really believe I was saying it, but it just felt like the right thing to say. It was a bartender, and she'd screwed up and gotten somebody wasted, and two people died. And she put her head down and nodded and just looked up and said, "Okay, we'll do it together." And it was like, you could see the defense lawyer just fall apart. But it was because nobody had listened to her. It's like, and I think it's one of the things, and I don't want to go too off topic, but it's like when we're preparing our client or other witnesses for deposition, for direct, for cross, when we that old adage that we completely reject on, keeping your answers short, only answer the question that's asked, never say this, never do that. All we're telling him is like, look, I have no faith in you, no trust. This is probably going to go really, really poorly. And by the way, tell the truth versus, empowering witnesses. And it's something I learned years ago from Don Keenan when he and David Ball were balancing each other out really, really nicely years and years ago. But, I remember one of the great things I learned from Keenan in kind of the early reptile days was empowering your witness. He called them the major truths. Major truths always sounded weird to me, so I said core truths. Like what is absolutely at the core of your testimony in this part of the case that makes this person an important witness in the case, and really nailing down what those core truths were. 99% of the time, if not 100% of the time, I think the witnesses did better than they would have had we not worked to identify their core truths. And same with jury selection. Like what is their truth? Not what is my truth transposed onto them, hoping they mirror back and relate to me, but like, where are they really coming from? Because at some point, that shit's going to come out. And I'd rather it be in voir dire than in deliberations.
Yeah, it's true. And to stay on the top, of knowing that you got it right. You said that, right? You'd rather make sure you get it right in jury selection than know you got it wrong after the verdict. Yeah. How many times you've been in a moment where you just don't know, right? Like you've got this feeling that you should get rid of juror number 3 just because of, I don't know, what do you want to say? The science behind it, right? Like that there's no way they can be, take, for example, again, here's another great story that I always, and it's relevant because it helped me recently. But John Romano talks about working with a trial consultant, and they were picking a jury. I think it was a malpractice case. And it had to do with, no, I'm sorry, I get it wrong. It was a insurance agent or an insurance adjuster. And the trial consultant wanted to keep that person on the jury. And John says, no way can we keep that person on the jury. It's not going to happen. And the consultant says, no, trust me, you got to keep this person on. And this person had a shift, this juror had a shift because forgetting about their profession, but they were able to insert themselves in the moment based on the family dynamic, similar situations in life, experiences, and they wound up being a really good juror. And I just had that happen in a case as well. Our case involved, there was going to be some math, there was going to be some reconstruction stuff, things like that. And this one juror was a professor with a, for all things, a math professor. And, my colleague that I was with trying the case was like, there's no way this person can stay. They're going to be way ahead of the facts. It's going to, if there's, we don't even understand all the math, and they're going to be figuring it out on their own, making conclusions. And I said, you know what? You're right. You're correct that this person should go based on all the boxes you check. But I felt something in my gut when I was having a conversation with this person, and we connected. Now, I didn't know that for certain at the time, but I had a feeling. So Kenny, I think like you said this before, sometimes you're in the moment and you've got a gut feeling that you need to go in that direction. And it turned out the witness the juror was favorable for us, and understood it and was able to set some of their professional notions aside and got to the right result. So I think there's those moments, right, that no matter how many books you read or seminars you go to or mock juries you try to go through, at the end of the day, you got to make a gut decision based on personality, right? It's kind of like that, hiring that person based on the how well they did at the job interview, versus maybe something they have on their application or in their resume. You're taking the person, if you will, not necessarily the baggage.
Tom, you alluded earlier to a case with catastrophic injuries. It was a big case. This was an 8-figure case. Like most trial lawyers, not every single case you handle is an 8-figure case. When you've had cases in recent cases in particular with really challenging facts, what do you do with those challenging facts in voir dire?
Yeah, Kenny, that's right. And you mentioned a recent case that we had resulted in an 8-figure result, and horrific set of circumstances, facts, and injuries, and just absolutely life-changing injuries. But even in those cases, even though that you have good facts and you have a bad defendant, let's say, and something that a jury can really get behind, right? We all hear about that bad truck driver or that bad company with the bad product that they knew about, and juries want to. We start to think about the reptile, right? In that fact pattern. But as you pointed out, those are not all the cases, right? And you and I, we have cases sometimes that come about as bad facts, and particularly up here in the Northeast. I know not in the sunny, warm weather in South Carolina, but we get snow and ice up here, and premises cases or slip and fall cases are tough, and it's oftentimes that you'll get a insurance adjuster on the phone, and they right away will tell you that your client is 50% at fault. And you'll get mediators that'll tell you that. And those facts are, they'll say to you, you've got bad facts. Well, why do we have necessarily bad facts? But let's assume that they might be right, that we have a scenario with bad facts. And there was a case shortly after our catastrophic case that we went to trial on that was a set of bad facts. There was some facts about the plaintiff that were not great, and we were worried about that. But you know what? What do we do with that? It's kind of everything we talked about a little while ago in the beginnings of our conversation, and that is honesty, right? Or as Nick said, brutal honesty. And so true. You have to be brutally honest about the facts of your case. And you have to find out, I guess what I would encourage is when you're sitting there and doing your outline, when you have that set of facts, whether it be something in the plaintiff's background, your client's background that troubles you, maybe it's the way the crash occurred or the incident occurred, or maybe the way the plaintiff used the product in that moment. Whatever it is, when you're planning your outline and your questions that you're going to ask, if there is a point, a boiling point, or something that is so scary to you, it needs to be asked. For example, how many of you believe that when somebody is walking on a slippery surface, that that person is at fault no matter what? Get the hands going up. Let's have a conversation about that. Ms. Jones, do you mind if we talk about that for a moment? I'd like to hear from you. Yeah, sure. And we start talking about that. Find out who in the room believes that if somebody slips and falls on ice, it has to be their fault. Somebody trips walking into Walmart, it has to be their fault. Somebody has a malfunction or something with their car, it has to be their fault because they didn't do a proper review or look at warnings. I think that's the part of it, Kenny, of how I was and my law partner, how we were successfully able to get over a bad set of facts is we went head on with one of our very first questions. Now, what I will say to you is the defense doesn't like that. Why didn't they like that in that case? Because we lost a substantial part of our panel. But that takes time to work through that. We were certainly okay with it. We had some challenges from a perspective of timing. Certain things had to move at a rate of pace that they should have, and they didn't. Why? Because we lost a considerable amount. I don't know exactly the numbers, but I'm just going to ballpark it. If we had 50 jurors, we might have blown through 32 of them just on one question. But as as we have this conversation, when do I want to know that answer? Do I want to know the answer when I get a no cause or a defense verdict and I start asking all the jurors, well, you never asked me if I thought if, Jimmy was walking on ice, if I thought he was going to be at fault. You want to know that up front. So I think that goes back to some of these brutal honesties. Hey, folks, listen, I'm going to tell you here. I'm going to openly admit to you, this isn't a great set of facts. But here's why I think that this may be the right case for you. And you kind of just go into it. And it worked out. I firmly believe that the folks that we had on our jury were there with an open mind. But I think if we listen to our fears and didn't ask that question, or the pressure sometimes of defense counsel in saying that we need to speed this up, this is taking too long, you can't ask those questions, right? You know how that goes. Then we feel the pressures, the external pressures to not accomplish what we're there to do. And sometimes our job is not easy. Sometimes we just have to be willing to hang in there and, like a boxer, I guess, and take those blows, but knowing that you're doing the just thing for your client. So that's, I guess, the best way that I would answer that is what, we're going to have tough cases. We're going to have bad facts, and just be honest about those facts.
Tom, in New York, are you all allowed to talk to the jurors after the verdict?
We are.
In any of those conversations that you've had with jurors post-verdict, have they alluded back to anything that happened in voir dire? I mean, is there a common thread that you see that runs from, in essence, the first time you meet them all the way through these post-verdict discussions? I mean, are you seeing kind of that connective tissue in any way?
The one thing that I'll say, right, we all hear the adage about them paying attention to you and how you interact with the court, how you interact with defense counsel, how you interact in general, they're always paying attention to you, right? We've read that, we've heard that. That is something that I've heard feedback on for sure. I think what's challenging sometimes is when you have a case that settles during trial and you still get the opportunity to talk to the jury after the fact. And they feel, jurors don't feel like they've had closure, right? But now it's kind of interesting, this role reversal. Your clients have closure in a way, you may have closure, but now the jury feels as if they don't have closure and they feel more inclined to talk about it. And I will say this to you, it's interesting. More jurors may want to talk with you about a particular set of facts when they can you'll know, I guess, the more the jurors got behind the facts, I guess I'll say, by the number of them that want to stick around and talk about the case. Whereas if you don't really have a great case, they don't always want to stick around and talk to you about it. I just read an article, actually. Do you ever get the emails, Paul Luvera's emails?
I don't think I've gotten his emails. I get a lot of emails, but I don't think I get anything from Luvera.
Yeah, so I'll forward you. I don't know what the listserv is. It's not a listserv, I'm sorry, but it's like a newsletter, let's say. And he just sent something out about talking to jurors, and it was really interesting. It was almost on the psychology behind it, and said, just stop worrying about asking the jurors why they did what they did, because sometimes they just don't know. In a lot of ways, they came in there, and the reason they did what they did is because of their beliefs and their values. Now, they may give you an answer, but it's probably not the real reason they did what they did. It was a really interesting article and pointed to what we said. I'll send it to you, and maybe somehow you can link it so folks can read about it.
Please do. All right. Speaking of links and people following up and all that good stuff, Tom, people who want to get in touch with you, be it about jury selection, that 8-figure case you hit on was actually, I believe, against a law enforcement agency. If they want to discuss cases, strategies, whatever it may be, inside New York, outside New York, what's the best way for folks to get in touch with you?
Sure. So, reaching directly out, the name of our firm is John Froman Attorneys. And we are something really great about our firm. And we have been a long-standing firm in our community, third-generation firm, almost 60 years been around. But we're in Buffalo, and you can email me if you want, which is Grillo, GRILLO, at fromenlaw.com. That's FROMEN law.com. Our website is fromenlaw.com. And you can call me directly if you want. Our office is 716-855-1222. And of course, my cell is 716-465-7011. Many folks have picked up the phone when I've needed them. So I'd be more than happy to talk with anyone that has a question about anything that they're dealing with in their practice, and we'll all learn together. I'm going to share just a quick story on why we should reach out to folks in our practice. So during that case that you spoke against the police agency, I reached out to a lawyer, or I reached out on a listserv for some information. And this lawyer, who was from the New England area, believe it or not, that a New England guy wants to talk to a Bills fan. But in any event, he picked up the phone, and he was away on vacation. And this man talked to me for 90 minutes. Never met him before, trial lawyer. And he said, I'll tell you what, I'm away from my office, but you will have a box of materials within 72 hours. And sure enough, not only did he talk to me for 90 minutes, but he sent me a package of materials that were crucial to our trial. So we're blessed that we're able to do this profession, that you and I got a chance to meet with each other, and we're surrounded with so many amazing people that are just there to help us do a great job, make ourselves better, and get justice for our clients.
And Tom, you beat me to it. I was getting ready to ask, what else would you like to talk about? What have we not talked about that you don't want this podcast to end without you having the opportunity to share?
Wow. So, Kenny, I prepared for everything else. I mean, but that's the one question I didn't prepare for. Joking aside, obviously, Kenny, the one thing I would say is this: is that as I've been practicing now, God, it's hard to believe that I'm in my 20th year of practice, and all of our experiences and things that we've learned. I would say this: number one, realize that you don't know everything. Find a great mentor. And I've been certainly blessed in that John Froman is an absolute incredible mentor to me, teacher, and provides incredible resources for us to do such a great job and represent our clients. So I would say that, and there's so many other great mentors. And we've mentioned so many names, on this call, from the Satch Olivers to the John Romanos to the Joe Freeds and folks like that are willing to, that have been there before us. They're doing great things and amazing things and willing to pick up the phone. So I would encourage you, anyone that's listening, number one, don't be afraid to pick up the phone. I know I said that to you just when we were in Vegas together. At any point in time, someone's going to pick the phone and take your call. So don't be afraid to do that. Don't be afraid to ask questions. Maybe you don't feel comfortable doing it out in the public on a listserv or something like that. Do it privately. And listen, worst case scenario, the person doesn't return your call, they don't respond. I guarantee you there's 100 other amazing trial lawyers or folks out there that are willing to help you. And I guess the last thing I'll say is this: as soon as you possibly can, try to work with some consultants. Try to work with somebody that has been there and done it, if you will. So whether that be another trial lawyer, whether that be a consultant, there's all these consultants. You don't necessarily have to hire them on a particular case, but you can just call them and just pick their brains on certain issues. Work out fee structures, however you can figure out the budget to make it work. So I think those are my two bits of advice. I mean, we could probably go on forever. I mean, I feel like I enjoy having these conversations with you, and that's really what it feels like. So thank you, Kenny.
Yeah, man. Tom, thank you so much for your time. Ladies and gentlemen, this has been Best Practices with Kenny Berger, our guest today, Buffalo trial lawyer Tom Grillo, and we look forward to being with all of you again soon. Take care.